Morning, ladies and gentlemen. Welcome to the Countryside Rights of Way panel on the 14th of March at 10 o'clock. Can I firstly take apologies, particularly from our chairman, who I understand is in hospital with a stomach problem. So hopefully he'll be up and about fairly soon and will be at least able to be back for planning next week. So apologies from him. Do we have any other apologies?
Yes, thank you, Chair. I've received apologies from councillors Mark Winnington, Jack Abrahams, Jill Waring and David Williams. Thank you.
Do we have any declarations of interest? No. Minutes of the meeting held on the 21st of February 2025. We're all in agreement? No matters, no problems, no nothing.
Thank you.
Thank you very much. We move on to item 4. Laura, we're with you.
Thank you, Chair, members. This is an application to add a public bridleway along Gradbach Mill Lane to Brook, Quarnford. The line of the route is marked A to B on the plan attached to Appendix B. This application is supported by historical evidence. I can confirm that the local member supports the route being added as a public bridleway only and supports the comments made by Quarnford Parish Council, which can be found at Appendix G. Turning to the recommendation, that is that a modification order should be made to add a byway open to all traffic along the line of the route marked A to B on the plan attached to Appendix B. Turning to the evidence, the historical evidence consists of the Alstonfields, Worslow, Lower Elkstones Enclosure Award dated 1839, the handover documentation dated 1929, Bartholomew's map dated 1902, and Ordnance Survey maps dated 1881 to 1990. The applicant also submitted a quarter session stopping up order for a route in the Heaton Parish, dated 1874, and the Heaton Parish Rights of Way Survey, dated 1949. The application route is listed as an unclassified county road in the list of streets, which is maintained under Section 36 of the Highways Act 1980. While this confirms that this road is publicly maintained, it doesn't establish the route's legal status. The enclosure award, in this case, identifies a route as Gradbach Road, 30 feet wide. The details recorded as one other public road and highway to be called Gradbach Road, commencing from the forest bottom in the township of Heaton in its present eastwardly direction over the end of Gradbach Common to the public carriage road near Gradbach Mill Pool. The map accompanying the ward clearly shows and sets out the entirety of the route. This statement reveals that the route was a public carriage road, suggesting the use of the route was of a higher status than that of a public footpath or bridleway and would have been considered a route for use by the public by any means. The enclosure award is conclusive evidence of a public carriage road from the junction at Love Lane to Brook at Forest Bottom. The public nature of the route is ratified by the handover documentation. The route is also recorded and shown on the Bartholomew map in the vicinity of Gradbach Mill Lane. The Ordnance Survey maps also show the physical existence of the route since 1881. Whilst these maps do show the physical existence of the route, they cannot clarify the status. In accordance with the Masters case, the route can be said to be of the character which makes it more likely than not to be used by walkers and horse riders than vehicular traffic. Therefore, motorised vehicles' rights remain, suggesting the most likely status would be that of a byway open to all traffic between the points marked A to B on the plan attached to Appendix B. As such, the Natural Environment and Rural Communities Act 2006 must be evaluated. Under Section 67(2)(b) of the Act, motorised vehicle rights would not be extinguished if the route was recorded on the Section 36 list of streets, but not on the definitive map and statement immediately before the Act's commencement. In this instance, the route qualifies for this exemption, preserving vehicular rights. This raises the possibility of designating the route as a byway open to all traffic, defined under Section 66(1) of the Wildlife and Countryside Act 1981 as a highway over which the public have a right-of-way for vehicular and all other kinds of traffic, but which is primarily used by the public as a footpath or bridleway. The enclosure award provides sufficient evidence to allege that public vehicular rights subsist over the route and therefore remain intact. Following circulation of the report, several comments from local residents and the parish council, which the local member supported, were made in respect of the report, and concerns were raised with regards to the unsuitability of the route for motorised vehicular traffic. These comments and officers' responses can be seen at Appendix G to the report bundle. It is important to note that officers fully recognise and respect any legitimate concerns that have been raised in relation to the safety and suitability of the application route. However, it is essential to clarify that such matters fall outside the scope of this tribunal of fact. Our focus here is solely on examining the historical evidence to determine the existence and status of public rights of way that exist in law and relying on the legal maxim, once a highway, always a highway. The evidence is suggestive of higher rights over the application route, and this route will be exempt from the NERC Act due to its inclusion on the Section 36 list, and therefore a byway open to all traffic will be the appropriate designation. There is a two-stage test, one of which must be satisfied before a modification order can be made. All the evidence must be weighed and evaluated, and a conclusion reached whether the alleged route subsists on the balance of probabilities or is reasonably alleged to subsist. For the first test to be satisfied, it will be necessary to show that on the balance of probabilities the right-of-way does exist. For the second test to be satisfied, the question is whether a reasonable person could reasonably allege a right-of-way exists, having considered all the evidence. In conclusion, although the application was made for the addition of a public bridleway, having regard to all of the evidence, in particular the enclosure award and the inclusion of the route on the Section 36 list, officers consider that there is sufficient evidence to suggest that higher public rights are in existence over the route and that the most appropriate status for the route is a byway open to all traffic. Officers consider that the evidence is sufficiently compelling on the balance of probabilities that a byway open to all traffic exists over the route marked A to B on the map attached to Appendix B, and that a modification order should be made to add the route as such to the definitive map and statement. Thank you. I'm happy to take any questions.
Thanks very much. You've heard the report. Do we have any comments?
Thank you, Mr. Chairman. No, I have no comments on this. I absolutely agree with the officer, 100%.
So you're proposing?
I would happily propose that we accept this recommendation.
I'll second it purely on the evidence. I mean, we don't get many with the evidence is as simple and laid out as it is on this one, really. Okay, we've got the parish council not wanting to go for the full thing, but as you said, once a highway, always a highway. It's listed as a highway open for all traffic previously, and I think we've got to go along with that. So I'll gladly second the proposition.
You've heard all the evidence, that the evidence submitted by the applicant and that the discovery by the County Council is sufficient to conclude that a byway open to all traffic which is not shown on the definitive map and statement subsists along the application route shown marked A to B on the plan attached as Appendix B to this report, and that an order should be made to add a byway open to all traffic shown on the plan attached to Appendix B and marked A to B to the definitive map and statement of public rights of way for the district of Staffordshire Moorlands. Are we all in agreement? Agreed. That's agreed. Thank you very much. Can we now move to item 5? Laura, I think we're still with you.
Yes, thank you, Chair, members. This is an application to add a public bridleway along Michael's Lane at Wootton. The line of the route is marked A to B, B to C, C to D and D to E on the plan attached to Appendix B. I can confirm that there have been no comments from the local member. Turning to the recommendation, that is that a modification order should be made to add a byway open to all traffic along the line of the route marked B to D on the plan attached to Appendix B. In support of the application, the applicant has submitted the road and maintenance status records of Staffordshire County Council dated 2020, The Staffordshire list of streets dated 2018, the handover map of 1929, the Ellestone Wootton tithe map dated 1844, the Yates's map of 1774, the Bartholomew's map of 1831 and the Greenwood's map of 1819. The application route is listed as an unclassified county road on the list of streets, which is maintained under Section 36 of the Highways Act 1980. While this is conclusive evidence of the Highways Authority's acceptance of maintenance responsibilities, it does not establish the route's legal status. Turning to the tithe documentation, the sole purpose of the tithe documents was to identify land subject to paying the tithe. A highway crossing land would reduce its productivity and value, although this would be true if the route was public or private. In this case, the route is depicted within the plots of land as two dashed parallel lines coloured in sienna, the same colour as other routes in the local area, tentatively suggesting that the route carries higher status than a footpath or bridleway. The route is depicted on commercial maps dating back to the earliest representation on the Yates's map of 1774. The route appears on each map. Although the level of accuracy is difficult to determine, the application route is still visible nevertheless. The map shows a physical feature on the ground at the time of the surveys, and the physical existence of the route is not disputed as it still exists today as a highway maintainable at public expense. The commercial maps are supportive in identifying the application route being part of the highway network, although they cannot confirm regarding the status of the route shown. The Ordnance Survey maps dating back to 1881, again provide a picture of the physical feature of the claimed route as a dashed pecked line with the annotation Michael's Lane alongside. The naming of the lane on the Ordnance Survey map carries some inference of public status, however it offers less conclusions in terms of the nature of the rights over the route. The application route runs from a public highway just north of Northwood Farm in the parish of Ellestone. The route continues in a generally north to northwest direction through Nedswood to meet with Hall Lane to the northeast in the parish of Wootton. The application route has a metalled surface, an all-purpose highway from point A to point B. The surface from point B to point D is a grass lane in nature and remains as such until point D, where again the surface is metalled to point E. The central section of the route from points B to D demonstrate the required character for the addition to the definitive map and statement. The remaining sections from A to B and D to D are not of the required character, being metalled and all-purpose highways. It cannot therefore be accepted that these parts of the route have the required character to be included on the definitive map and statement. This report is focused on determining the nature of the public right which exists along the application route, specifically whether it carries public footpath, public bridleway rights, or whether higher rights such as those pertaining to a restricted byway or a byway open to all traffic. The historical evidence, the depiction of the route on the handover map, the sienna colouring on the tithe map, and the depiction of the route on the commercial and ordnance survey maps for a period spanning over 200 years, coupled with the acceptance of the public maintenance provided by the handover map of 1929, indicates that it is likely that some public vehicular use of the route was historically established. In accordance with the master's case, the route can be said to be of the character between points B to D, which makes it more likely than not to be used by walkers and horse riders than vehicular traffic. Therefore, motorised vehicle rights remain, suggesting it is most likely status would be that of a byway open to all traffic between the points marked B to D. As such, the Natural Environment and Rural Communities Act 2006 must be evaluated. Under Section 67(2)(b) of this Act, motorised vehicle rights would not have been extinguished if the route was recorded on the Section 36 list of streets, but not on the definitive map immediately before the Act's commencement. In this instance, the route qualifies for this exemption, preserving vehicular rights. Therefore, this raises the possibility of designating the route as a byway open to all traffic, defined under Section 66(1) of the Wildlife and Countryside Act 1981, as a highway over which the public have a right-of-way for all vehicular and all other kinds of traffic, but which is primarily used by the public as a footpath or bridleway. Upon consultation of the report, correspondence was received from local landowners along the line of the application route, describing the route being used frequently by walkers, horse riders and cyclists, with the occasional use by farm traffic, 4x4 vehicles, motocross and classic cars. There is a two-stage test, one of which must be satisfied before a modification order can be made. All of the evidence must be evaluated and weighed, and a conclusion reached whether the alleged route subsists on the balance of probabilities or is reasonably alleged to subsist. For the first test to be satisfied, it will be necessary to show that on a balance of probabilities the right of way does exist, and for the second test to be satisfied, the question is whether a reasonable person could reasonably allege a right of way exists, having considered all the relevant evidence. So to summarise, the evidence is insufficient to establish on the balance of probabilities the user rights and legal status of the route. However, when considering the second test of reasonable allegation, the historical evidence indicates a historical route on the ground for a period of 200 years, and the public nature of this route has been ratified by the recording on the Section 36 list. An acceptance of public use, including that of vehicular use of the route, supports the historical evidence and that the route has been used by the public as a through route by any means for many years. So although the application was made for the addition of a public bridleway, when considering all the evidence in its entirety, the historical evidence is suggestive of the existence of higher rights. The description and use of the route by motorised vehicle is consistent to align with that historical existence of a byway open to all traffic. This indicates that the public route, which fits the definition of a highway over which the public have a right of way for vehicular and all other kinds of traffic, but which is used by the public mainly for the purpose of which a footpath and bridleway are so used. The sections of the route marked B to D and D to E are a character which mean they are more likely to be used by vehicles and all-purpose highways, and therefore the recommendation is to not add those sections. However, based on the evidence, officers find that it is reasonable to allege that a byway open to all traffic exists over the section of the route marked B to D on the plan attached to Appendix B, and that a modification order should be made to add that section of the route as such to the definitive mapping statement. Thank you. I'm happy to take any questions.
Thank you very much. I think it's interesting when we start to talk about the existence of a footpath for 200 years. It brings the work of this committee into focus and makes it something that I've thoroughly enjoyed sitting on, and I think my colleagues would agree with that. Do we have any comments?
Just one this time, Mr. Chairman, thank you. Reading through some of the statements on here, and I can't remember which one it was now, and I've been scooting back. I normally mark it on my computer, but it's on paper today, sorry. But it was a comment about how many potholes along this route, someone had said. When you upgrade to a boat order, so it's open to other traffic then, does that make a difference to where it sits in highways, as in for getting potholes done? Just asking out of interest. I was going to say on the first one as well, when it was a real thin route, you know, would that get upgraded just the same?
Yes, so it would fall under the highways rather than under the rights of way in order for potholes to be rectified and maintained on a byway.
Thank you. I was just wondering if highways jump it up, but I have no other questions, and I see how you've got to the conclusion of B to D, and I understand how that got changed. So again, I'm happy to go with the officer's recommendation on this.
Has the local member come back on this one, Councillor Philip Atkins?
No.
I should tell him about the maintenance. He's got to maintain his road. No, I go along with it as well, with the officer's recommendation. Thank you for an excellent report again.
Do we have a proposal?
I will second.
Proposed and second?
Yes, I'll second.
Thank you very much. All those in favour? Thank you very much. To agenda item 6. Sorry, I should actually have said what the recommendation was. Yes. The recommendation actually is that the evidence is sufficient to show that a byway open to all traffic, which is not shown on the definitive map, and statement is reasonably alleged to subsist along the route shown marked B to D on the plan attached and Appendix B to the report, that an order should be made to add the byway open to all traffic shown on the path on the plan attached and Appendix B and marked B to D to the definitive map and statement of public rights of way for the district of East Staffordshire, and we have approved that. Thank you very much. So let's now move to agenda item 6. Claire, I think we're now with you.
Yes, thank you, Chair. May I just start by confirming that there have been no objections from the local member, Councillor Pert. This report concerns an application made under Section 53 of the Wildlife and Countryside Act 1981 for the addition of a byway open to all traffic between the highway next to Brann Farm and the highway northeast of Chapel at Offley Marsh in Eccleshall. The application route is marked A to B on Appendix B of your report and was submitted by Martin Ray. This application is based on historical evidence. The recommendation here is to accept the application and to make an order to add the alleged route as a byway open to all traffic to the definitive map and statement. The applicant's evidence included a copy of an enclosure award plan and an ordnance survey map dated 1884. The enclosure award dated 1845 is one of the most important historical documents available. The plan clearly shows a network of routes within Offley Hay which are marked with the letters A to N. The award accompanying the plan describes the route annotated with the letter M in the section of the award headed Public Carriage Roads. The commissioners for the award set out various roads in the Public Carriage Roads section of the award, and the section of the plan marked with the letter M is detailed under the section Public Carriage Roads and would appear to be the route that's the subject of this application. The enclosure award describes the way as leading out of Road D, opposite allotment 18, southwardly over the said common called Offley Hay, to Road E, opposite an allotment number 2, being an old township road. The location of the description of the claimed route being recorded under the Public Carriage Road section, together with the width of the route being recorded as 15 feet broad, is highly suggestive of that of public status. The award is quite clear in its language, stating that the road is a public carriage road. Moving on to the Ordnance Survey map of 1884, it shows the route in an area of Offley Marsh, leading in a southerly direction towards Brann Farm, which would appear to correspond with that of the route in question. Ordnance survey maps provide good evidence of the physical existence of the features they show at the time of the survey, but they do not assign status to those routes. The route is also shown on the 1901 and the 1924 maps in the same manner as that as the 1884. From the 1880s onwards, the maps included a disclaimer to the effect that the depiction of any path, track or way is not evidence of the existence of any public rights of way. As set out above, the Ordnance Survey maps do not distinguish between public and private routes. They should therefore be viewed in conjunction with other evidence. In summary, the enclosure award states categorically that the route is a public carriage road. Other documentation, in this example, the Ordnance Survey map, all show a physical feature capable of carrying carriageway rights, and this continues to be the case today. The enclosure award states that the rights are public, and so whilst the supporting documentation is quiet on this, the maxim of once a highway, always a highway can be applied. An initial consultation was undertaken in 1998 when the application was made, and letters were received from 2 landowners, both stating that they considered the route to be public. More recently, landowners were consulted, but no responses were received. On consideration of the evidence, it's your officer's opinion that the application for the addition of the route between the points A and B on the plan attached to the report passes the legal test under Section 53, 3C1 of the Wildlife and Countryside Act 1981. I would just like to add to the recommendation that the width of the byway open to all traffic should be a minimum of 15 feet. This is the width that's referred to in the enclosure award. I'm happy to take any questions.
Thank you for the report, Claire. An old one from Martin Ray, 1st of May 1998. Now, the evidence to me is the width 15 feet as per the Enclosure Act. I mean, the Enclosure Act 1884. I mean, it's good evidence, so thank you very much for what you've done, and I will gladly propose it.
I'll second that, Chair.
That the evidence discovered is sufficient to conclude that a byway open to all traffic, which is not shown on the definitive map and statement, subsists along the line of the route marked A to B on the plan attached at Appendix B on the balance of probabilities that an order should be made to add the alleged public right-of-way shown marked A to B on the plan attached at Appendix B to the definitive map and statement of public rights of way as a byway open to all traffic for the borough of Stafford. That's the recommendation. Are we all in agreement?
Could I just add, could you just mention that in the recommendation we also need to refer to the width? So could we just add that, I've omitted it from the report, but if we can just add the width is 15 feet.
Can we add the in agreement to that? That's
Thank
agreed.
you. Thank you.
Fine. Can I now move to agenda item 7? Before we go into this, we have had some late evidence submitted on this application. This has been sitting in the waiting list to come to committee for at least over a year when the evidence has been available. The deadlines for submitting evidence have been missed on several occasions. The final deadline for this meeting has also been missed on the basis that there is a claim that there's further evidence. That evidence is too late to be considered today, so I need the views of committee about whether you are wishing to consider the late evidence, bearing in mind the information that we have. The applicant will have the opportunity to go to appeal if they're not satisfied with whatever our decision is today. So, Laura, can I just ask if you want to add anything to that?
So, yes, the late evidence has been considered very thoroughly by officers. It has only been received after the end of the consultation period. So officers have considered that evidence. However, it hasn't changed the recommendation. We don't consider it sufficient to change the recommendation on this occasion. But I will add that it has been considered very thoroughly and it hasn't changed the recommendation. Obviously, once you've listened to my presentation today, you'll be able to see what you think after that.
Are you content that we will take the item and continue, or do you wish to delay?
Thank you, Mr. Chairman. They're given plenty of time, is in my view, and I think the officers have been more than generous if they've considered something that's arrived late to start with. I do not see the point in not discussing this today, and there's a process to follow. There's a time frame to follow, there's a process to follow, and like you said earlier, they can always go to appeal. I would prefer to continue. Thank you.
I see this from the other side, unfortunately, on this occasion. Having been here when we've had evidence and they've gone to appeal, it's not just going to appeal. Going to appeal costs us money. Because if we make a decision, they can overrule, we have to come back again. The report is there in its fullness. We can just delay it and then hear. I mean, will we hear the additional evidence today? We won't, will we? 'Cause we
Yes, you will hear it all today. Everything that I've had up until the 12th of March, I think, so that was Wednesday, I've considered very thoroughly.
So when's the additional evidence coming? Before the 12th of March?
Yes,
So,
yeah.
so basically we're getting everything today.
You will hear everything today that we've had to date.
In
yes.
that case, then, I will go with the...
And the appendices and all the correspondence that we have had are all been circulated to members.
That's that last bit that came through.
It did, yes. Yes, so it has all been circulated, so you have seen everything that we've had.
Just, we don't want to prejudge what we're looking at as far as the evidence that you're going to produce for us in your report. But one of the things that I would be anxious about if we saw an argument for delaying is that if it made a significant difference to your recommendations, and I think possibly in your report you're going to make it clear that it doesn't make any difference. And so I agree that we should take it forward and deal with it this morning. Okay.
But even if it did make a difference, it's us to make the decision on hearing what you've got to say, isn't it? So really, it's still our decision whichever way you go. So for that reason, I'd prefer to go ahead then. Okay?
Okay, thank you very much.
Thank you. So this is an application for the upgrade of Public Footpath 16 Waterhouses and part of Public Footpath 20 Waterhouses to Public Bridleways, and for the addition of a Public Bridleway from Public Footpath 20 to the River Hamps and from Public Footpath 20 to Pikelow Lane Waterhouses. I can confirm that there have been no comments from the local member. Turning to the recommendation, that is to reject the application in its entirety based upon the reasons contained within the report and outlined today, to decide not to make an order to upgrade or add the claim routes marked A to B, B to C, C to D and C to E on the plan attached to Appendix B to the definitive mapping statement. The original application was submitted in January 2020 based upon historical evidence. The evidence submitted consisted of the deposited railway plan and book of reference for the Leek and Cauldron Low Hartington Light Railway dated 1901, the plan of the proposed station and goods yards at Sparrow Lee by Joseph Forsyth of 1900s, the parish survey card for Public Footpath 16 Waterhouses, an extract of the Ordnance Survey map and photographic evidence. Officers also considered parish survey cards for Public Footpaths 20, 109, 24 and 36 Waterhouses and Bridleway 9 Grindon. Officers also considered the extinguishment and creation orders for routes in connection with the application route marked C to D on the plan attached to Appendix B and the Waterhouses tithe map dated 1845. Turning to the deposited railway plan and book of reference, railway plans were produced by the railway companies for major schemes of work and were authorised by private Acts of Parliament. From 1838, these plans and the associated books of reference were required to be deposited with local public authorities. As detailed within the report, the 1901 deposited railway plan shows in plot number 36A a bridle road within the plot. The book of reference contains a single reference to Bridle Road. However, no owner is assigned, and therefore this does not infer public rights. The routes surrounding the plots of land and shown as two dashed lines can be identified within plots 36, 37 and 38. These are all recorded as public footpaths in the ownership of Charles Ball, Waterfall Parish Council and Mayfield Rural District Council. The reference to the parish and district councils, together with the reference to public footpaths, are highly suggestive of public footpaths within these plots. In plot 2 of the plan in the Island Parish, the deposited railway plan refers to a bridle road and pool. The owner assigned to that plot is Earl Cathcart alone, which is more likely to infer private rights over any assigned bridle road. The deposited railway plan therefore does not support the contention that the route in question had the status of a public bridleway, or that it was a continuous route with any higher status than a public footpath, and provides a strong element of doubt to the reference that inference that a public bridleway exists over the claimed route. The parish survey cards in respect of the entirety of the application route are examined as part of the investigation and commented upon in detail within the report. The National Parks and Access to the Countryside Act 1949 imposed a duty on parish and district councils to provide information on public rights of way within their area. In relation to Public Footpath 16, the parish survey card itself contains several inconsistencies. The route appears to commence in the neighbouring parish of Grindon as a CRB, which was subsequently reconsidered to be a footpath as part of the special review. In the statement on the reverse of the parish survey card, it refers to two routes, one of which is less direct, and the route recorded on the definitive mapping statement is a direct route across the field via 4 stone-style gaps, which would indicate use on foot only. Only one route is recorded on the map, casting an element of doubt on the description. Public Footpath 20 Waterhouses is identified as a footpath and is joined by 16 Waterhouses. Both cards refer to this. The description of Public Footpath 20 indicates the presence of stone-style gaps also, and refers to a wooden footbridge over a brook. This does not infer any higher rights that were in place over the route. Public footpath 24 is identified as a footpath on the parish survey card, and whilst the annotation of a bridle gate is referenced by crossing the Light Valley Railway, this description of the furniture on the route is that and does not identify the use of the route. Turning to the parish survey card for public footpath 36, again this indicates the use of the route as a public footpath and leaves the Light Valley Railway via a bridle gate, which again is a description of the furniture and not the use of the route, which continues over the River Hamps by a footbridge to the farm. Whilst the parish survey cards and plans can provide supportive evidence for an upgrade of a route, other supportive evidence would be required to satisfy the legal test on the balance of probabilities. In respect of the route marked C to D on the plan, officers discovered public path extinguishment and creation orders in respect of the routes, which are on the ground at the time of the parish survey. There is no evidence that there were any higher rights over the routes which were extinguished by the order. The creation order confirms the details of the routes which were created at the same time of these extinguishments and remain as public footpaths on the ground today. These created routes do not form part of this application. In subsequent correspondence, the applicant stated that they have no further evidence to support this section of the route marked C to D and requested to withdraw this part of the application. However, once an application has been submitted and accepted, it cannot be withdrawn in part or in whole, and as a result, this section of the route, along with the application in its entirety, will need to be determined as part of this whole process. Turning to the tithe map evidence, the sole purpose of the tithe documentation was to identify land subject to paying the tithe. A highway crossing the land would reduce its productivity and value, although this could be true if the route was public or private. In plot 2 of the plan, the annotation foot-road is depicted along the line of the application route marked A to B, and that the tithe was payable in respect of that plot of land. This evidence again is strongly suggestive of a footpath on the ground at the time of the survey with no higher rights. The Ordnance Survey map document the physical features present at the time of the survey, but they do not determine the legal status of routes. The maps from 1881 to 1955 confirm the route's existence on the ground. Notably, the 1881 map includes an abbreviation BR along the route near to public footpath 16 Waterhouses. However, this designation does not extend southward, where the corresponding 1881 map records the annotation FP. All other maps display the abbreviation FP alongside the routes within the application area. The map suggests the presence of a ford across the River Hamps and a footbridge, although it is unclear whether these features are public or private. Whilst the Ordnance Survey maps can provide historical evidence of a route's presence, they cannot serve as definitive proof of a legal status. So moving to the comments on the report, the landowners provided detailed evidence and signed declarations of their knowledge of the route over a 60-year period, which is included in the bundle at Appendix E to the report. The landowner evidence suggests that use of the routes has been on foot, with the occasional permissive use for local residents on horseback. The landowners provided evidence in respect of the use of the route during their occupation and also noted the extinguishment and creation orders over the land. The landowners contend that the use from Sparrowley Farm to the River Hamps is a private one. The landowners also indicated that public footpath 20, which public footpath 16 joins slightly to the north, has stiles and a footbridge over the brook, which were replaced by stepping stones in 1980. Landowners also noted that a private farm track is used for agricultural access, which connects Sparrowley Farm to the field barn located in one of the fields to the north, which public footpath 16 crosses. Following the deadline of the consultation period, the applicant submitted 7 user evidence forms dated February 2025, suggesting that there had been public use of the route on horseback prior to challenge in 2010. This is 10 years prior to the application date. The applicant implies that bridle gates along the public footpath 16 were blocked up in 2010. Officers have thoroughly reviewed this evidence of use. However, this does not change the recommendation within the report. Members can see the user evidence forms and correspondence within the addendum and further correspondence which was circulated on the 12th of March. The applicant requests to amend the line of the application route to align with the submitted user evidence forms and suggests that the line of the route goes to the River Hamps and not the Manifold Light Railway. Upon review of the 7 user evidence forms, one user has only 7 years use and the other 17 prior to the date of challenge in 2010. Of the other 5 users who have met the required 20-year continuous use prior to 2010, 4 belong to 2 families. Notably, one of these individuals was the original applicant who did not submit a user form with the original application in 2020. 2 of these users resided at a local farm, which could suggest their use was permissive. And this raises concerns that it was permissive rather than as of right. The evidence presented lacks the necessary credibility to satisfy the higher legal test of the balance of probabilities. Consequently, the weight and probity are limited, and so the recommendation remains unchanged. The user evidence forms do not sufficiently demonstrate use by the general public, the wider community, or the public at large. While the law does not specify a minimum number of user evidence forms, it is imperative to demonstrate use by the public at large. Where evidence indicates use primarily by families or limited sectors of the community, it fails to establish the public as a whole. The available evidence is insufficient to establish the route as a bridleway for the requisite 20-year period preceding the date of challenge. So there are 2 legal tests in respect of the claim route from C to D and C to E, one of which must be satisfied before a modification order can be made. All the evidence must be weighed and evaluated for a conclusion to be reached, whether the route subsists on a balance of probabilities or is reasonably alleged to subsist. For the first test to be satisfied, it will be necessary to show that on the balance of probabilities, the right-of-way does exist. For the second test to be satisfied, the question is whether a reasonable person could reasonably allege the right-of-way to exist, having considered all the relevant evidence. So with regards to the upgrade of the routes marked A to B and B to C, the burden is on the applicant to show, on the balance of probabilities, that it is more likely than not the definitive map and statement are incorrect. The existing classification of the routes as public footpaths must remain unless or until the panel is of the view that the definitive map and statement are wrong. If the evidence is evenly balanced, then the existing classification of the routes as public footpaths on the definitive map and statement prevails. So to summarise, there is insufficient compelling evidence that supports the contention that any of the application routes in question are of the status of a public bridleway. The evidence fails to show that a public right-of-way with the status of a public bridleway marked C to D and C to E on the plan attached to Appendix B, which is not shown on the map, subsists or can reasonably be alleged to subsist. The evidence submitted needs to satisfy the test, the balance of probabilities, where the application is for an upgrade of an existing public right-of-way. The original historical evidence and subsequent user evidence is insufficient to establish on the balance of probabilities that a public right-of-way with the status of a public bridleway marked A to B and B to C subsists. So therefore it's the opinion of officers that the County Council should not make a modification order to add or to upgrade the routes to public bridleway status on the definitive map and statement of public rights-of-way for Staffordshire moorlands, and that the application should be rejected in its entirety, based upon the reasons contained within the report and outlined today. Thank you. I'm happy to take any questions.
Thank you very much. Very comprehensive report. Do we have any comments?
I do have just a couple of little questions. Firstly, I apologise that people write to you in some of the ways they do when I was reading this. There is no need, you just have a job to do. But the one person mentions that the heading of the report is wrong. Could you just clarify whether that is correct or not? And that the River Hamps isn't the end, but the manifold trial. Could you just put a little bit of context for me, please?
So I think that the applicant has tried to change the route that was applied for originally, that went over the manifold trail to the River Hamps. So nothing really turns on the fact that the heading is different to the opinion of the applicant or what we've wrote on the report. So the map which is attached to the report is the evidence that we've based the report upon, and that was created by our mapping team on the application map that they submitted.
Perfect, thank you. I just wanted that clarified because it sounded like someone was getting very cross about how you'd done this, and I just wanted to make sure it was above board and nothing wrong. Then, once again, I have to absolutely agree with the officers on this, and we do need to reject it. So I again will put my hand up and say I propose that.
Looking at balance of probabilities or even reasonable alleged exist, the horses were permitted use, as the people say, really. The user forms are amiss in various aspects. One question I have, it doesn't, I mean, I'm going to go with officer's recommendation, but why, like when Martin Ray applies, his name's on the form. When this applicant's come, it's been all taken out. Is there any reason for that? As they're making a public request, shouldn't their name remain on the form so the public can know who's making the application?
So in terms of GDPR and data protection, we try to align with the Stafford County Council's data protection, making sure that people's personal data isn't available where it needn't be. Because all of this information is uploaded on the websites for the purposes of this panel, we do tend to take out personal information just so that it's not available on the website in that respect.
Just my views, Chair. I mean, okay, take address out, but the name should be there so people know who's making these claims. Really, just in case. If we looked at Martin Ray over the years, we know as a sister, Martin's trying to get things changed. So I really believe we should know who's making the application. It's a personal thing. You've got your reason for not doing it, but just I feel as a member of his panel, we should know who's making the application. That's all. But I will gladly second this. We go with officer's recommendation that point 209, opinion of officer that the county council should not make a modification in order to upgrade.
Thank you very much. The recommendation is that the evidence submitted by the applicant and that discovered by the County Council is not sufficient to conclude that a public bridle way subsists along the application route shown marked A to B, B to C and C to D, and C to E on the plan attached at Appendix B of this report, that an order should not be made to add the alleged route shown on the plan attached at Appendix B and marked C to D and C to E to the definitive map and statement of public rights of way for the district of Staffordshire Moorlands, that an order should not be made to upgrade the alleged route shown on the plan attached at Appendix B and marked A to B, B to C to the definitive map and statement of public rights of way of the district of Staffordshire Moorlands. Those in favour of the recommendation? That's approved. Thank you. Can I just, we don't have any items. Can I just take this opportunity on behalf of the members of this panel to thank you and your officers, and I hope that you would take back to them our appreciation of the quality of the reports that this committee has received over the past 4 years. And it's also been a very enjoyable committee to sit on. So thank you very much indeed for that. Could I just also make one warning that with a number of members who are not seeking re-election, you will not have enough trained members for this committee to sit after the election. And so whoever is going to set up some training, I think they should have that ready to go. Otherwise, you may have a major delay in considering applications. So thank you once again on behalf of all of the members, and wish you all the very best. Thank you very much indeed. I close the meeting at, what is it? 10:49. Bad, I think. Thank you very much indeed. Thank you for your attendance.